Good morning, everyone. My clock says 9:30, so we're going to begin. All right, welcome back for those of you who participated in part one, and welcome to the new faces about to participate in part two. I'm State Water Board member and co-hearing officer Tam Doduk. To join us shortly, because I see their stuff here, to my right will be board chair and co-hearing officer Felicia Marcus, and then to the chair's right will be board member Didi Diadamo. To my left are staff attorney Dana Heinrich, also another attorney, Nicole Kenzie, welcome to the team, Nicole. Supervising Water Resource Control Engineer Connie Mittenhofer, and Senior Environmental Scientist Greg Brown. We also have other staff assisting us today. Just to make sure you're all in the right place, today we are holding the pre-hearing conference for part two of the California Waterfix Project Water Right Change Petition Hearing. I don't see a mass exodus, so the agenda for today's meeting was distributed on October 16th. And we are now being joined by board member Diadamo. In suggesting topics for this pre-hearing conference, a number of parties raised issues that we want to respond to with clear direction today. In addition to addressing new issues, we will also go over some of the issues that have been addressed previously. All of the parties are expected to have read the October 30th, 2015 hearing notice and our previous rulings for this hearing, and, very importantly, to adhere to those procedures and ruling. To assist you, we have provided a guidance document as an enclosure to today's agenda that summarizes some of the hearing procedures and issues addressed in prior rulings. The agenda and guidance documents are available on our website, and there are some extra copies in the back of the room. We want to ensure that all the parties understand our prior rulings and understand how to proceed in part two of this hearing. We may update the guidance document following this pre-hearing conference. So let me just give you a rough outline of the topics we'll be covering today. As usual, there'll be the exciting general three announcements that those of you who participated in part one I know cannot wait to hear again, followed by a brief background on the water rights petition process. Then we'll cover procedural and evidentiary motions, the scope of part two and related issues. Then we'll discuss the order of presentation and group consolidations. Next will be hearing time limits. Then we'll cover instructions on how to offer exhibits into evidence and settlement agreements. Let the record note that we have now also been joined by board chair and co-hearing officer Felicia Marcus. After providing instructions on these topics, I will give the parties an opportunity to come up and ask any clarifying questions. This is not an opportunity to raise arguments about our rulings. This is not an opportunity to further discuss other topics. It is to ask clarifying questions if there's any additional confusion regarding the direction and instructions that I'm about to give. All right, with that, let's go ahead and get to these exciting safety announcements and other housekeeping matters. First of all, please take a look around and identify the exit closest to you. In the event of an emergency, an alarm will sound and we will evacuate this room immediately. Please take your valuables with you and use the stairways, not the elevators, down to the first floor and exit to the relocation site across the street in the park. If you're not able to use the stairs, please flag down one of the safety people who will be wearing orange fluorescent colored clothing. Can't miss them. And you'll be protected, you will be directed to a protective area. Also, as you may have noticed coming into the building, today is the Great California Shakeout, in which we will be participating at 10:19 this morning. Hopefully, we will be on a break during that time. But during this exercise, we will practice how to protect ourselves in the event of an earthquake, a serious matter. We urge you to participate the drill on your own, which should only take a few minutes. And if we are during the break, then I do believe the cameras will be off and you will not be recorded. The safe response to an earthquake is to drop, cover, and hold on. Drop to the floor on your hands and preferably below the seats. Cover your head and neck with one arm and hand. Take cover under a sturdy desk or table, if one is handy, and hold on firmly until the shaking stops. If no table is nearby, drop to the floor near an interior wall and cover your head and neck with your arms and hands. Stay away from windows and mirrors. Do not leave a building during the earthquake. If you have mobility impairments and cannot move, protect your head and neck with a sturdy object or your arms if you are able. Okay. Next exciting announcement, this pre-hearing conference is being webcasted and recorded. Both the audio and video portions are being recorded. So when you come up to the podium, speak clearly into the microphone and begin by stating your name and affiliation. Has been a while, I might have forgotten you. A court reporter is present today and will be preparing a transcript of this pre-hearing conference. Thank you, Candace, for coming back. The transcript will be posted on the State Water Board's California Waterfix Petition Hearing website as soon as possible. If you would like to receive the transcript sooner, you may make arrangements with the court reporter. All right, we'll see how today goes. I'll try to take a morning break for the court reporter, and if necessary, an afternoon break as well as a lunch break. We have a lot to cover, but I'm hopeful that we can be efficient and cover it all in one day. Not that I wouldn't be thrilled to see all of you again tomorrow, but efficiency is always best. And then finally, my most important announcement of the day. Please take a moment, because it has been a while. You know how I am about this. Please take a moment and turn off or mute your cell phones and all other noise-making devices. Even if you think they're already off, please take a moment and double-check. Everyone is double-checking. All right. Settle in. I'm about to go into a somewhat brief but detailed background on water rights hearings. All right. Before we begin with the agenda items, we want to provide some background information on how this type of water right proceeding is different from the State Water Board's usual public meetings. This is a recap for most of you, but we may have some new participants here today who are not familiar with the difference between a water right hearings and our usual public policy meetings. So please bear with us. A water right hearing is I should make one of you come up and test you on this. A water right hearing is a quasi-judicial proceeding, a formal hearing conducted by the State Water Board to develop a record of evidence relevant to the key issues identified in the hearing notice. We will rely on this evidentiary record to make our decision. While it is a public meeting, participation in a water right hearing is limited to designated parties. Parties are those who intend to offer evidence and call witnesses, conduct cross-examination, make objections and legal argument, and otherwise participate in the evidentiary portion of the hearing. Witnesses called by designated parties to offer evidence into the record are subject to cross-examination by other parties. The deadline to submit a notice of intent to appear in order to participate as a party has passed. Interested persons are those who plan to present policy statements and not be actively involved in the evidentiary portion of the hearing. Unlike witness testimony, policy statements are not evidence, and the State Water Board will not rely on policy statements in support of the factual determinations in its decision. Also, unlike witnesses who testify on behalf of parties, Interested persons are not subject to cross-examination. Written policy statements will be accepted via email throughout Part 2 of the change petition hearing. The next opportunity for interested persons to present the policy statements early will be on January 18th, 2018. Unlike a general public meeting, a water right hearing has a tightly structured format. Participants are expected to adhere to specific requirements, including but not limited to deadlines and specifications for written submissions, time limits, order of participation, distribution of documents, and other matters that we will discuss in this pre-hearing conference. As hearing officers, Chair Marcus and I act much like judges to ensure that the hearing is conducted in an orderly fashion. Following the hearing, we will provide guidance to the hearing team in preparing the draft order to be considered by all State Water Board members at a future board meeting. The public will have an opportunity to comment on the draft order before the board meeting. For the State Water Board to approve a water right change petition, the petitioners must establish and the board must find that the proposed change will not injure any other legal user of the water involved or unreasonably affect fish and wildlife. In addition, a special provision contained in the Delta Reform Act of 2009 requires the board to include appropriate delta flow criteria as a condition of any approval of a water right change petition for the California Waterfix project. The board will also consider whether the project is in the public interest. All right, that is your water right hearing 101 for the day. With that, let's now turn to the first item on the agenda for today's pre-hearing conference, and that would be procedural and evidentiary motions. First, we will not be reconsidering procedural issues that we have already ruled upon. Let me repeat that. We will not be reconsidering procedural issues that we have already ruled upon. We have already ruled that the proposed project described by petitioners in Part 1 and the environmental documents for the project are adequate to proceed with Part 2 of the hearing. We have also already ruled that completion of other regulatory processes is not necessary for us to proceed with Part 2 of our hearing. We acknowledge the protestants' interest in understanding whether and to what extent the Bureau of Reclamation intends to participate in the project, but petitioners have not proposed any amendments to the petition, so we will proceed based on the project as it has been described in this hearing. We will rule on procedural motions as appropriate and necessary. We may request a party to promptly respond to a motion. That includes verbally during the course of the hearing. We are committed to providing a fair and open process in this hearing and will provide parties ample opportunities to be heard and to participate. That said, excessive motion practice is discouraged, strongly discouraged. Due to the number of parties, we strongly discourage the flurries of unsolicited correspondence, follow-up comments on rulings, and duplicative motions or requests on issues already addressed. It bears emphasis that we generally disfavor motions for reconsideration of our procedural rulings. We may not respond to duplicative comments, motion, or requests moving forward in this hearing. The parties should also read and follow the guidance we have provided concerning evidentiary objections in the guidance document enclosed with today's agenda, and on pages 13 to 15 of our August 31st, 2017 ruling. We expect parties to be judicious in making evidentiary objections. As a reminder, we have already ruled that parties should not make any objections to the admissibility of testimony before the hearing resumes for presentation of Part 2, Cases in Chief. We will review the written testimony carefully before the hearing resumes to ensure that the testimony is relevant, is within the scope of Part 2, and sufficiently reliable to be admissible. All right, let's move on to the scope of Part 2 and related issues. In suggesting topics for the pre-hearing conference, a number of parties raised questions about the scope of Part 2 and the extent to which Part 1 issues may be addressed in Part 2. The hearing issues to be addressed in Part 2 are listed in the hearing notice and on pages 12 and 13 of our August 31st, 2017 ruling. Evidence presented during a party's case in chief must be relevant to the Part 2 key hearing issues. We particularly encourage parties to submit proposed permit terms and conditions that would resolve issue raised in the protest as part of their case in chief. With respect to cross-examination, rebuttal, and revisiting Part 1 issue, cross-examination of witnesses is not limited to the scope of the witness's direct testimony if the questions are relevant to Part 2 issues. We will also allow cross-examination of witnesses on Part 1 issues as long as the line of questioning directly relates to the witness's direct testimony in Part 2. Let me repeat that. Cross-examination of witnesses is not limited to the scope of the witness's direct testimony if the questions are relevant to Part 2 issues. And we will allow cross-examination of witnesses on Part 1 issues as long as the questioning directly relates to the witness's direct testimony in Part 2. Moving on, during rebuttal, parties may present evidence that directly responds to another party's case in chief. Parties may present rebuttal evidence that is within the scope of either Part 1 or Part 2 if it is in direct response to another party's Part 2 case in chief. For example, rebuttal is the appropriate time to present evidence of potential injury to legal users from a term or condition presented in another party's case in chief in Part 2. So again, during rebuttal, parties may present rebuttal evidence that is within the scope of either Part 1 or Part 2 if it is in direct response to another party's Part 2 case in chief. Since we are allowing parties the opportunity to address Part 1 issues through cross-examination or rebuttal in Part 2, they will have to make a strong showing that they were not able to raise a Part 1 issue in cross-examination or rebuttal in Part 2 in order to revisit a Part 1 issue after Part 2 of the hearing has concluded. All right, let's move on to not yet, Mr. Becerra. Although I appreciate the break. Let's move on to the scope of the hearing and environmental documentations, or environmental documents. Some parties have asked for clarification about the relationship between the key hearing issues and the environmental documents for the project. The purpose of this proceeding is for the board to gather evidence and act upon the petition for changes to petitioner's water rights. The adequacy of the final EIR and other environmental documents for purposes of CEQA is not a key hearing issue. The board is not the lead agency responsible for preparation of the final EIR or other environmental documents for the Waterfix project. The board is not required to certify that the documents comply with environmental laws. Although the board must comply with CEQA in connection with its decision on the change petition, and the board must ensure that the final EIR is adequate for this purpose, the board is not required to hold an evidentiary hearing on issues concerning CEQA compliance, and the parties may not present testimony or other evidence on those issues. However, it is appropriate for parties to test the validity of specific data and conclusions in the final EIR and other documents for purposes of the board's consideration of the potential impacts of the project and the findings that the board must make under the Water Code before we may approve the water right change petition. Again, it is appropriate for parties to test the validity of specific data and conclusions in the final EIR and other documents for the purposes of the board's consideration of potential impacts and for the findings that we must make under the Water Code. Providing that any testimony or other evidence concerning the validity of specific information contained in the environmental documents is relevant to the key hearing issues, these are substantive issues that may be raised during the hearing. Let me move on while you are all jotting down questions that you will be bringing up, I'm sure. Let's talk about delta flow criteria. Some parties have also asked how the board will develop delta flow criteria for purposes of this proceeding. Let's be very clear here. Board staff will not be presenting evidence in this proceeding, so it is up to the parties to present proposals and supporting evidence for appropriate delta flow criteria. The board will determine what delta flow criteria are appropriate to include as conditions of any approval of the change petition based on the entire administrative record, including the parties' proposals and evidence, the 2010 flow criteria report, and the scientific basis report for Phase 2 of the Bay Delta Plan update, provided that the report is included in the record. We also addressed this issue in our August 31st, 2017 ruling. All right, I've covered quite a bit. Mr. Becerra, would you like to kick off the questioning session? And again, I remind you, we're not seeking for feedback or arguments about what I just delivered. But any questions to clarify any remaining confusion, you may present them now.
Thank you. Thank you for allowing me to kick this off, I suppose.
Have we turned on your microphone?
Yeah, it is on. I guess I need to just speak closer to it. I had a couple of questions about what you said, as demonstrated by the fact I popped right up. First, on the issue about, as I understood what you said, it was if we wanted to present evidence after Part 2 on Part 1 issues, we'd have to show that we were unable to do so via cross or rebuttal.
That is correct.
Okay, and so my question, and we've been through this issue a little bit previously, is there is modeling associated with the biological opinions that has not been addressed in this hearing at all, has not been presented. We in the Sacramento Valley water users asked to extend Part 1 in order to deal with that modeling, and our motion was denied, essentially on the grounds that we could deal with it later. So I have a real quandary as to what exactly we should do at this point. I assume that I noticed that Reclamation at least designated modelers as witnesses. I believe DWR did as well. I therefore expect that we'll see new modeling results as part of the petitioner's case in chief. I don't know exactly where we go from there. I mean, I suppose that those of us who are concerned about water supply impacts theoretically could present rebuttal testimony on Part 1 issues in Part 2. That's not ideal, I think.
May also question those modeling experts during your cross-examination.
Oh, yes, we absolutely can do that, but the modeling is so technical and so involved that in order to do an adequate job explaining what it means, that really requires technical testimony. I mean, I don't feel I can get all of the potential points out on cross, and frankly, I don't know that you want to sit through me trying to do that. So I'm trying to understand at what point in this hearing, if there is new modeling based on the biological opinions, protestants will be able to present testimony about the water supply impacts. So that's one question. I can happy to delay my next question, or I can state my next question now.
You may go ahead and state your next question. However, just to clarify, from my understanding of your question, if you're not able to get to the questions that you need to have addressed through cross-examination or through presentation of your rebuttal, you will have an opportunity to demonstrate or at least present arguments as to why you were not able to do that and why additional revisiting of that issue is necessary before we move forward into this hearing. So at some point during the next, I guess, 6 months or so of Part 2 in 2018, you will have the opportunity, you and other parties will have the opportunity to demonstrate or at least to provide arguments as to why certain issues, perhaps the one that you just provided, were not able to be raised and addressed during cross-examination or rebuttal, and we will make that determination at that point.
Okay, and just trying to speculate as to where this ends up. I mean, those of us who are protestants, I think based on this guidance, we may have to assume that we need to present very substantial rebuttal testimony on Part 1 issues in Part 2. And I don't know if that's where you want to go with this or not. And so at some point, some additional clarity as to how you would like to proceed would be great. And it seems like we can't really have that conversation until after November 30th because we won't see petitioner's testimony until then. But shortly after that, I think we will have to have a conversation about how to deal with that issue.
So noted, Mr. Becerra.
Okay. The second question I have is, you stated there towards the end about the various reports that the board has prepared or board staff has prepared on delta flows, including a scientific basis report. How do you expect those will be involved in this hearing? I heard you state clearly state board staff will not be testifying. So will those reports be part of the record even if witnesses don't testify to them? I mean, it's a very important issue because we have to, if the scientific basis report is part of this record, we may have to present substantial testimony about it at some point. So some clarity as to how those reports are involved in this hearing would be very useful.
Thank you, Mr. Becerra. Ms. Nickel.
Good morning. Meredith Nickel on behalf of numerous protestants. Should I state them?
Ms. Nickel, if it'll help your back, or at least it'll help me because I'm in pain looking at your back. If you could move to the taller microphone.
I'm not usually the tallest one in the room. Do I need to state the protestants upon who I'm appearing, or 'cause it's
I
quite
don't
a
believe
list.
that's necessary for
Okay.
now.
Okay. A point of clarification regarding the statement I heard regarding motions to reconsider being discouraged, which I understand. For purposes of exhaustion of administrative remedies, is it necessary to bring a motion for reconsideration?
Ms. Heinrich?
No, I don't believe it is.
Thank you.
Ms. Meserve, thank you for waiting.
Good morning. Yeah, I wasn't going to go to the other one. I learned that the hard way. I'm here on behalf of Land, Yolo County, Friends of Stone Lakes, and several other parties. I have a couple of easy questions and one maybe that will take further thought and others may want to weigh in on. The first question I had was with respect to the status of the final EIR as evidence. As we're working with our Part 2 witnesses, obviously the final EIR and the Notice of Determination documents will be referenced quite a bit. And so it's my understanding that the final EIR is not yet in evidence, and I would like to know whether I am required to bring forth the parts of the EIR that my witnesses are relying upon, or whether the petitioners or the board will be placing that, in the evidentiary process.
Does the petitioner wish to?
And I guess I would add the other permits that have been issued this summer I think I would have the same question.
Mr. Mizell?
You come here if you want.
That's all right. Good morning, Trip Mizell, DWR. Simple answer would be yes, the department does intend to submit the final environmental document as an exhibit, as evidence. We will probably be referencing the staff exhibit number since that was provided for us, and that's how we will be referencing it when submitting it into evidence.
So it would be SWRCB 3, and that would be inclusive of the final EIR. I think for citation purposes, we'll want to make clear what part of the set of documents.
It was my understanding of the exhibit list that there was one exhibit for the draft and there was one exhibit for the final. I can review the exhibit list again and see if there needs to be any modifications to my answer, but we'll be using the staff exhibit number if it's appropriate to do so. Otherwise, we'll enter it in as a DWR exhibit.
And then that would be the same for the state-issued ITP and the biological opinions.
To the extent that we rely upon those documents, we'll be using them as exhibits, yes.
Okay. It would be I think it would help a lot with the hearing record to maybe clarify that point and get it as one exhibit number for each of those items.
Go on, Ms. Meserve.
Thank you. The other question I had was, I have several clients that were noticed for Part 1 but not Part 2. And so I understand the issue about being able to bring up Part 1 issues with respect to cross-exam and rebuttal evidence. And I take that to mean, but want to clarify that if those types of issues come up that have to do with water user Part 1 issues, that those protestants could come forth at that time, even though they're not noticed for Part 2.
That's a good point, Ms. Meserve. We will definitely consider your participation in Part 2 for the purposes of addressing Part 1 issues, yes.
Thank you. Yeah, it's something I mentioned to hearing staff, and I was assured that there, at least generally, that there shouldn't be an issue with that, but I just want to make sure, because obviously I don't think folks could have anticipated necessarily the way things have turned out with the Part 1 issues. Then last, I heard you say this morning that the Water Board will proceed on the project as described in this hearing. And it's a major effort, private and public, to participate in this hearing and present evidence in response to the petitions that were submitted in 2015. And I would like clarification, for the sake of the resources being put into this process, that only the project described in the petition is being considered in this hearing process, and that any different project would need to be reflected in a new or revised petition describing that different project, so that we could prepare responsive testimony and exhibits and evidence for that.
And you were seeking that clarification.
Yes, I am.
Thank you. We will note that.
Thank you.
Next.
Morning, thank you. My name is Joseph Kowalski. I'm here with the Sierra Club California and Friends of the River. Just asking for a little more clarification on the issue of that we're not allowed, the parties aren't allowed to really question the sufficiency of the final EIR. First time. Parties aren't allowed to question the sufficiency of the final EIR, but one of the key issues is whether it should be entered into the administrative record. So I was wondering if you could just clarify a little more what would be allowed in regards to questioning whether it should be entered without discussing its validity as a document.
Ms. Heinrich, that sounds like a legal question.
So the adequacy of the environmental document for purposes of CEQA is not a key hearing issue, but it will be offered by the department as an exhibit. So the validity of the information in the document for purposes of the findings that the Water Board needs to make under the Water Code, and to the extent that any of the information in the document is relevant to the key hearing issues, then that is within the scope of the evidentiary hearing.
Thank you.
Does that help?
That helps, yeah.
Okay.
Thank you.
Mr. O'Loughlin.
Good morning again, Tim O'Loughlin, San Joaquin Tributaries Authority. I have two questions regarding appropriate delta flow criteria. So if I'm understanding you correctly, basically every party to the proceeding in regards to their case in chief in phase 2 should put forward what they believe the appropriate delta flow criteria should be pursuant to the Water Code for the approval of the petition. Is that correct?
If you have a proposal to make, we would like to hear it.
Okay. So I'm just trying to figure out how this process plays out over time. So everybody makes their appropriate delta flow criteria proposals. We cross-examine all the various proposals that are being made. And then at some later point in time, what happens?
The board will make a decision to include what we determine to be appropriate flow criteria should we approve this petition. It will go into a draft order, which will then be distributed, and we will hold a board hearing on it, our usual water rights order consideration process.
Well, I think that's where the problem lies. So here's the concern that I have with that approach, and I thought that would be your answer. So there's a missing step in there. So right now we have a petition in front of you that has a very specific set of proposed criteria based on their September letter detailing how they were looking at operating the project, okay? And basically it's D1641 flows plus the OCAP-BO. And I know there's other nuances to it, but basically that's it. So everybody makes these appropriate delta flow criteria reports. You go back in and do the voodoo that you guys do, and you come up and you say, nope, we don't like that. We have something that is totally different for appropriate delta flow criteria, and it's not D1641, and it's not the biological opinions. Well, the problem is if this petition is premised on these petitioners' water rights, and you go back in and change what is proposed as far as delta inflow, delta bypass, and delta outflow, then that can change how reservoir operations operate upstream and the availability of water for senior water right holders. So my concern is that you haven't defined yet in this process that if the numbers change, how is it that we're going to make sure or have a process to identify that senior legal users of water are going to be protected. And then this also goes to the point that if you do come up with a draft appropriate delta flow criteria proposal, are the petitioners even going to accept it? Because, yes, we don't know. So that's the other component about the problem with appropriate delta flow. You're leaving us no place to go. You're going to issue a draft order and then say, well, we're done. You can comment on this draft order, but that doesn't get back to the hearing record that we may need in order to protect phase one. And we talked about this previously. It's in all my letters to you previously, and I keep restating the same thing. So I think you need to think, a suggestion, think a little bit more about how you see appropriate delta flow criteria proceeding forward. I get that we should put it in our documents coming up on November 30th, but think about the process unfolding from there to ensure that the due process rights of the water right holders are protected.
Thank you, Mr. O'Loughlin. And since you were so articulate, I will ignore the fact that you are critiquing our ruling, which I admonish people not to do. But it was a good point, and we will take that under consideration.
Thank you. I have one other point, and it was briefly mentioned by the previous speaker. I'm very much concerned with the admission of reports into evidence without a witness. So I would totally understand if, let's say, I'll use NRDC or the Bay Institute, and let's say they want to put in evidence in phase two, and they use your delta flow criteria report from 2010. And they say, we're going to use this as part of our basis about why the petition doesn't have appropriate delta flow criteria. Totally understand it, get it. They'll have a witness there. The witness will testify what they glean from that document and how they view that document and how it should be treated by the board. The problem with admitting a document without cross-examination on behalf of the board is there's no witness, there's no cross-examination, and it appears that it's being submitted for the truth of the matter asserted, whatever the truth of the matter asserted is. So I think you should be careful about admitting those reports. In fact, I will just tell you ahead of time, we will move to exclude them if you do move to admit them, because it's incumbent upon the parties out here that if they want to use those reports and criteria, they can. And quite honestly, I can't think of an exception in the evidence code or anywhere else.
And now you're starting to make your argument, Mr. O'Loughlin.
Okay, so basically, I think you should reconsider your thought process on that one in regards to how you admit those specific documents and maybe rely on the parties instead, that if they think that they're valuable and have information that should be submitted, you should do it in that fashion.
All right.
Thank you.
What time is it? It's 10:12. And what time is the shakeout? I don't mean to interrupt you, Mr. Brodsky. Yes, but the shakeout is at 10:19. All right, let's take another 5 minutes and then we will take a break. Mr. Brodsky.
Thank you, Madam Hearing Officer. Michael Brodsky on behalf of Save the California Delta Alliance. I wanted to just be a little bit more specific about the points that Mr. O'Loughlin and Ms. Meserve raised. As far as Ms. Meserve's point about, we sort of at this point have a placeholder project description, and the petitioners are in the process of reformulating what they want to do. It doesn't appear that 3 intakes and 2 tunnels are on the table anymore. That if anything, it'll probably be 1 intake and 1 tunnel. So we are, Save the California Delta Alliance is a very small organization with limited resources. We've held pancake breakfasts and golf tournaments and costume parties and everything you can think of to raise money. And we're spending about $400,000 on experts to show to you what the impacts on Delta recreation of 3 intakes and 2 tunnels are. So if 3 weeks from now, petitioner decides that it's 1 intake and 1 tunnel, given the circumstances, we feel we should be compensated for the money that we've wasted because petitioner didn't have their project description ready. And I guess in terms of you considering what you said you were going to consider for Ms. Meserve, I'd appreciate if you could consider that problem also.
I'm sorry, now you've lost me. We were considering her participation on behalf of parties who did not seek to participate in Part 2, but however may want to revisit some Part 1, meaning injury issue, as during the course of Part 2.
Right, yeah, I was referring to the second half of Ms. Meserve's point, which was that the board is only considering in these proceedings the project that is described in the petition, which is 3
Yes.
intakes and 2 tunnels. And you said you would take under consideration what happens if a week or 2 from now DWR decides that's not the project they want to build.
Okay.
And as a part of you taking that under consideration, I'd like you to take under consideration that DWR should compensate us for the money we've spent on experts to critique a project.
You'll have to work that out with DWR, Mr. Brodsky.
Okay, so is it futile then for me to make a motion for you to hold that? We believe the board is obligated to issue an order.
You may make that argument later. This is not the time.
Okay, thank you.
That does not mean we may grant it, but
You'll consider it. Okay. The second point is on appropriate delta flow criteria. Since there are no operating criteria for the project, right? There's nothing in the project description, nothing in the project that's before the board that is being proposed that there's any bypass flow. They're not agreeing to leave any amount of flow in the Sacramento River. They're not agreeing to limit what amount of water they'll take at what time of year during various flow conditions. The only operating criteria are that they'll operate the project so as to meet D1641. So if we're to propose appropriate delta flow criteria, then aren't we really proposing the outcome of phase 2 of the update of your water quality control plan? If the only operating criteria that are a part of the project is we'll meet D1641, then what is it that we're proposing as appropriate flow criteria? Flow standards throughout the delta? Or do you want us to propose operating criteria for the project that DWR didn't propose? In other words, would an
whatever you believe would address the potential injury that you perceive to result as the outcome of this project.
Okay, so that's very broad then. Okay, thank you very much.
Thank you, Mr. Brodsky. And with that, we will take a break until 10:30. And remember to do the Great California Shakeout. All right, if everyone could please take your seat. It is 10:30. We're going to resume, but before we get back to any clarifying questions people may have, let me ask you to do something right now, especially Ms. Meserve. Actually, no, you would not be on this list. Staff has compiled information received on the supplemental notice of intent to appear forms for each party, and there are copies of this information in the back of the room. This information was also posted on our website yesterday. I need the parties present to review the summary carefully to be sure that it properly reflects your party's participation in Part 2. And later on today, we'll give you time to bring any errors to our attention. All right, let's turn back. And Mr. Mizell, did you? No? You're just moving up closer. Okay.
Good morning, Jonathan Salmon, here on behalf of East Bay Municipal Utility District. I have a question about the flow criteria hearing issue for Part 2. Is it permissible to introduce evidence on delta flow criteria in Part 2 that relates to Part 1 issues?
As part of your rebuttal?
As part of the case in chief for Part 2.
Case in chief in Part 2 is focused on the key hearing issues for Part 2.
And my question is, given that delta flow criteria is stated as a Part 2 issue and not a Part 1 issue, can the evidence that's introduced on that issue in a Part 2 case in chief relate to protecting or responding to concerns that a party has raised in Part 1, injury to legal user of water, for example?
Will it also address potential injury, harm to fisheries and other resources? Or is it specific to just addressing injury to water user?
Would it be permissible to propose delta flow criteria for the Waterfix project and support that with evidence as to why those flow criteria are needed to protect against a Part 1 impact?
Yes.
Would it be permissible to introduce new evidence regarding those impacts to legal users of water if it directly relates to supporting the proposed delta criteria?
Is there a legal concern with that, Ms. Heinrich? As you can attest, during the course of this hearing, we've been very open to the introduction of potential terms, conditions, criteria. So I, at this point, don't see an issue with that.
Okay, thank you.
Ms. Desjardins.
Yeah, I, as an analyst, been trying to find what I might look at for operating the project to Decision 1641 criteria, because those are the only criteria that are not speculative. And I did go back and look at the EIR by the board for Decision 1641 and look at the EIR for the water quality, or the SED for the water quality control plan. And the impacts of this project just aren't addressed, and I'm not seeing the kind of analysis of operating the project just to these criteria with or without the exemption from the export to inflow. And I did raise these issues in comments on the environmental documents, but you know, what do I do if I feel that there isn't adequate documentation even to support the board's consideration of this petition to adopt the project under Decision 1641?
That's what we are here to determine, meaning this hearing is being conducted to obtain information so that we might act on the petition before us. If you have arguments specific to the validity, not of the document themselves, but of specific facts that this board would be considering, you should make that as part of your case in chief.
I'm just not seeing the kind of analysis, CEQA analysis, that I would expect. There was such a CEQA analysis, for example, when the board adopted Decision 1641. The board had an EIR. There were analyses of the impact of the amending the water rights for the joint point of diversion, and with the specific regulatory criteria. And
that was because
we don't have the
decision
resources necessarily to produce that
Decision
analysis.
1630 was our decision. We were responsible for developing the environmental document for that decision.
I'm talking about 1641. Decision
Yes,
1641.
sorry.
Yeah.
As we have stated numerous times, we are not the lead responsible agency for preparing the environmental documents for the water fix.
For the Waterfix project, but I did submit arguments that the board's adjudicatory proceeding, and in the precedent in Decision 1641, the board did have this document, and there's no subsequent document to Decision 1641 for me to look at the analysis and evaluate it, and it is an enormous, it's a fairly large amount of modeling to do to look at the project dust operated to Decision 1641 criteria. Furthermore, as far as Tim O'Loughlin's point, where he said, the board isn't testifying on the board's modeling, in Decision 1641, the board presented a witness with the board's EIR, and people were able to ask about.
So you're concurring with Mr. O'Loughlin's question?
Yeah, it's just a question of, I would like to at least be able to provide some testimony on the, what I see as a gap in the CEQA analysis for the board's decision. There's supposed to be a series documentation of the board's consideration of alternatives, and I'd like something that's adequate enough to look at and analyze.
Can I?
Go ahead.
I think we've been conversing about this back and forth for some time, and actually it's a good point. I'm going to try to make it in a different way, so I think it might be a little easier to digest. So this goes back to the appropriate delta flow criteria report again. So currently you have in front of you all these environmental documents. So you have an EIR, you got biological opinions, you got all this wonderful stuff in front of you, and you're exactly right. You're not the lead agency on the project. You don't have to do any of that. Totally agree with that. But here's my question for you and your staff again. So if we get down to a point later on down the line and you decide appropriate delta flow criteria is X plus 10, and it's not in an environmental impact report for the project, okay, then you're going to have to do a supplemental EIR or your own EIR to support your discretionary act on an appropriate delta flow criteria. That's what she's trying to say, I think. That's been the discussion that we've been having. Because clearly, well, I don't want to get into
Okay,
argument.
your point is made, Mr. O'Loughlin. You are not finished, Ms. Desjardins?
I just wanted to add, not seeking to increase work for the board, but in terms of limited resources of parties, having an analysis to look at is really important, an environmental analysis that's adequate.
All right. Mr. Mizell and then Mr. Jackson.
Good morning again. Trip Mizell, DWR. In reviewing the notice of intent to appear and the witness subject matter list over the last, several days, it comes to mind that there is a lot of overlap, which you would expect with a lot of the same parties, but also there's a lot of overlap in terms of topics that we've already discussed in part one. Is there any additional guidance that you can give us as to whether or not wholly repetitive testimony and exhibits will be permitted to come into part two that we've already reviewed in part one, but now are being presented under the guise of the public interest?
We will consider that. Obviously, we want to discourage duplicative filing of documents as well as presentation of testimony. But to the extent that it presents new aspects or there's new arguments to be made based on public interest, then certainly it belongs in part two. It might be a matter of we'll recognize it when we see it. It's kind of hard to proceed at this point with just from the NOI.
Thank you. And just one additional question. Earlier, Ms. Meserve, excuse me. Earlier, Ms. Meserve talked about part one parties that did not file an NOI for part two coming in during the course of part two. And I would just pose the question, is it not more appropriate for those part one non-noticed parties to petition the board in the manner in which you spoke of earlier during the procedure guidance you gave us? At the end, if their issues have not been addressed by the parties who have filed NOIs, then they would have the opportunity at that time to state the reasons why their issues had not been covered and then look for a limited reopener of part one. But I guess it's very difficult then to understand what the scope of the opportunity is for parties who've not filed an NOI to now come in if we simply say it's a second opportunity to voice your concerns.
Mr. Mizell, let me clarify. Ms. Meserve, and I believe perhaps only one or two other parties were parties who participated in part one that did not file NOIs to participate in part two. We're not talking about opening the floodgates for everyone to come in and participate in part two. It's only for those who participated, who were part one parties, who need to now, because we are expanding portions of part two through cross-examination and rebuttal, to revisit part one issues that will be considered for participation. And we're not talking about a lot. I think there were 3. Oh, okay. Well, maybe half a dozen. But so far, I believe Ms. Meserve is the only one who has voiced her request.
Okay, thank you for that additional clarification. I would, again, just suggest you had outlined already a procedure that would account for that possibility. And thank you for the clarification.
Michael Jackson on behalf of CWIN, CSBA, Aqua Alliance. We were part one parties. We intend to be part two parties. And I've got 3 sort of requests for some kind of further instruction. The first one is that we went through part one limited to evidence in regard to effects on legal users of water. The same activities, in fact, a number of my witnesses had portions struck as they tried to draw the conclusion that there were public trust problems, that there were public interest problems, that there were unreasonable effects on fish and wildlife problems. That's going to be pretty repetitive information, but it's for 3 different subjects that need to be covered in this hearing. Mm-hmm. So in trying to determine what to put in terms of testimony, I want to be sure that the parts that were moved to part two are still usable in
Part two.
in Part 2.
Correct.
And that additional information on the other 3 items, and perhaps back to item number 1, effect on legal water users, are still possible in order to cover the range of the issues we're trying to follow here. If testimony gets repetitive, I'm hoping that you will all look at it from the point of view of, well, we could have done it all together in the first place and done all 4. And so it has to be repetitive.
That was a very subtle admonition. Thank you, Mr. Jackson.
Well, I'm trying to learn. I have reviewed some of my Part 1 attitudes, and I think I ought to start.
Very well done, and we will certainly be receptive to that.
Thank you. And I can think of one instance in which I appreciate you being receptive after my performance. The second question goes back to, again, this sort of moving operations plan. I mean, in looking at but now with a specific reason in mind. The first is the Delta Reform Act requirement that you set out appropriate flows. The permit request, the operations plan for the original permit, seems to have moved through all of Part 1 and is now in the process of moving through the environmental documents. It causes a couple of questions. Do you want the testimony to cover everything from category, from the range that it started out as H3, H4, or some category like that in the project description, and has now reached the thing where it goes from 1.2 million acre feet of water less than they're getting today to 1.3 million acre feet of water more than they're getting today? And how do we develop a flow schedule without knowing which one it is? How do we recommend to you what the flow schedule should be, what the most efficient flow schedule would be for all of the uses when we don't really know how it's going to be operated? And where adaptive management makes this year's operation potentially different than next year's. And I'm having trouble with my witnesses trying to get a handle on that because they can't figure out what the ops plan is. We're giving flexibility because it might help, but it doesn't seem to mesh very well with what the Delta Reform Act required, which is some sort of consistent standard for flow. And I don't find guidance for that yet in the rulings. And I'm wondering if you could take a look at that again, which leads me to my third question, which is, let's assume that you, based on the testimony, the evidence in the record, the environmental document, as applied to your responsible agency requirements, result in something that's simply within the range of what's now the proposal. 1.2 million acre feet less than you've taken on average, or 1.3 million acre feet more than you've taken on average in the past? And how do we determine, and when do we determine who supplies the water one way or the other? In every hearing since 1987, when I started coming to these hearings, this has been established the flow has been established in the Water Quality Control Plan. This is new. And the Water Quality Control Plan had stages that got to the point of, okay, here's the standard. Who supplies it? How does it mesh with the water rights system? And I think that's the elephant in the room with a lot of the confusion, because everybody wants to know whether we're, whether this is only water supplied by the petitioners, or whether this may be water supplied by people that the petitioners' water rights outrank. And so is there going to be a determination of who supplies the water in this hearing, or do we really have to wait till the Water Quality Control Plan? This new addition by the Delta Reform Act is interesting, and I think it requires some attention. I don't know whether we need as we did in the Water Quality Control Plan, that I think it was a phase 4 that D1641 came out of. But the question here is, we're going to have to make this decision before we address who's responsible for delivering the water. I can't do a public interest analysis clearly until I know what that is. I certainly can't do a public trust analysis until I know what that is. And I don't know, with the sort of wide-ranging ops authority, how to determine what's unreasonable for fish and wildlife. And so I guess my request is for somebody in the legal staff to take a look at this and maybe opine. At least I would know what the rules were before November 30th.
I'm curious, those are good points, Mr. Jackson. I'm curious though, within the range of operations that have been discussed throughout this hearing, are you saying that you are unable to offer an opinion as to what you believe the operation plan should be?
Well, no, I can, I have a default position, which is would take the default position that the alternative of, I think it's boundary 2, while not the alternative that the state board asked them to look at in terms of alternative 8, is the closest to the 2010 document that I can get, because that would be the process I would go through. That's not going to give you very much in terms of how to streamline it. And I thought, it seems that what you're looking for is as much clarity as possible from the witnesses. And, given the environmental document problem, given adaptive management, and given a very wide-ranging operational situation, all the way from the Trinity River down to the San Joaquin, it's going to have significant differences both on fish and wildlife, on the public interest, and on the public trust. So,
thank you, Mr. Jackson. Yep. I like the new, helpful Mr. Jackson a lot.
Michael Breisky, Save the California Delta Alliance, again, very briefly. Just to make sure that the hearing officers and the board and the staff understand that as far as DWR is concerned, The application for the project that's before this board that they're asking you to approve has no description at all of how much water is going to be diverted, when it's going to be diverted, under what conditions it's going to be diverted. And you believe that under those circumstances, protestants have enough information to put on their cases in chief?
That's what we have said.
Okay, thank you. As far as just procedurally and Mr. Meisel's concern, we have a few witnesses listed. They're all experts, they're all highly qualified. We intend to keep our oral presentation very brief, to present in panels, and for the most part to rely on our written testimony, and that the witnesses are here basically in case board members have questions and for cross-examination. So we're going to keep it short.
You have become one of my favorites, Mr. Brodsky. Ms. Desjardins.
I just had a brief follow-up comments on Mr. Jackson commented on the water quality plan.
Not a comment, perhaps a request for clarification?
Request, yes. So the initial hearing notice indicated that this board would adopt only interim flow criteria in this proceeding, and that the more permanent flow criteria would be considered in the water quality plan update. But what I saw of the Phase 2 draft scientific basis report, they're only considering near-term operations, and there's no consideration of the Waterfix, although it was noticed for consideration there. And it would be helpful if the board would clarify whether the board still plans to consider and adopt flow criteria, more long-term flow criteria in the water quality plan update, because there is a concern that it won't be adequately addressed in either process.
Thank you, Ms. Desjardins. Any other questions based on what I've said so far? Thank you for those very helpful points that you've all raised and that we will be considering. Let me move on then. I've already asked everyone to take a look at the summary that staff prepared with respect to the parties' participation in Part 2. Let me move on to then discussing order of presentation and group consolidations. As we did in Part 1 of the hearing, we will provide a list of parties in Part 2 in a specific order for a presentation of direct testimony and cross-examination purposes, beginning with the petitioners. During the hearing, parties will be required to present their testimony when their party is called, or coordinate with another party to take their place. We will do our best to provide estimates for when parties should be ready, but these estimates are tentative and subject to change. Parties should not rely on these tentative estimates as a commitment by the hearing officers of a date certain to present their cases in chief. This is particularly important for those parties who did not participate in Part 1 and so may not be aware of these procedures. If a party cannot present on a particular day, it is that party's responsibility to coordinate with another party to take their place and give at least 3 days' notice to the hearing officers and the service list. We will not accept notices of unavailability from parties with scheduling conflicts that could have been avoided, or parties who provide late notice of scheduling conflicts and do not arrange a change in the order of presentation so the hearing can proceed without interruption. Proposals to present out of order are subject to approval by the hearing officers and should be presented, again, at least 3 days in advance. with so many participating parties, grouping among parties is highly encouraged. We encourage parties with common interests and common witnesses to work together to make the hearing process more efficient. In Part 1, some parties presented a consolidated case in chief or coordinated with other parties to present direct testimony from the same witness or group of witnesses as part of their case in chief. To promote efficiency, additional time for parties that consolidate all or portions of their cases may be allowed. Parties must submit any proposed groupings with their Part 2 testimony and exhibits no later than noon, November 30th, 2017. We will review the proposed groupings and issue a posted order of presentation after November 30th, but before January 18th. Let's talk about time limits. You know how much I love time limits. We plan to enforce time limits. Parties are encouraged to be efficient in presenting their testimony. And Mr. Brodsky, thank you again. Follow Mr. Brodsky's example. There you go. And they are also encouraged to be efficient in conducting cross-examination. Since written testimony will be submitted in advance of the hearing, it is unnecessary and unwise for witnesses to provide lengthy and detailed oral summary presentations. Time limits are subject to some flexibility if there is good cause demonstrated in an offer of proof. Parties must include any request for additional time with their written testimony and exhibits. So, a reminder of these time limits. Generally, parties will have up to 20 minutes per witness and up to 1 hour per party to summarize their case-in-chief testimony. Parties will have up to 1 hour to cross-examine each witness or witness panel. Let's talk about when to offer exhibits into evidence and about objections. Parties should be prepared to offer their testimony and exhibits into evidence immediately at the conclusion of their direct testimony, cross-examination, and any recross and redirect. Any objections to the admissibility of testimony and exhibits must be made early or in writing during the hearing when the testimony and exhibits are offered into evidence or earlier. This is similar to the process we undertook during the, I believe it was the rebuttal phase of Part 1. Oh, here it is. Consistent with the practices established in Part 1 of this hearing, parties must update their exhibit identification indices to include any exhibits introduced during cross-examination. The parties are not required to offer cross-examination exhibits into evidence, but if they elect to do so, they must formally offer their cross-examination exhibits into evidence by the deadline that we will establish later in the hearing process. Any questions with respect to time limits? Mr. Brodsky.
I'm not sure if I heard you say it or not, but there's 20 minutes for the opening statement also per party?
Ah, yes, I had forgotten about that. Yes, you also allowed an opening statement.
Okay. And then we have 3 parties on one protest. So we would not intend to use 3 hours, but would that mean that our limit was 3 hours?
If absolutely critical and necessary, although I'm sure you would be more succinct than that.
We will. Thank you.
Ms. Meserve.
Quick question. I believe in Part 1, once we finished presenting our evidence, our witnesses, cross, redirect, we were given 1 week to submit the exhibit list after that point. And I know there were certain times at which the additional couple days was necessary to figure out which exhibits should indeed be offered and whatnot. So I think You had said just now immediately, and I'm not sure that's what we did.
If I recall correctly, it was our process, our procedure that you verbally submit into the record the exhibits that you intend to introduce, so that others may voice any objections at that time. And I believe we allowed, was it a whole week? I thought it was 24 hours. We were that generous? Okay.
I think it varied based on the circumstances, but as a general rule, the parties should be prepared to offer their exhibits into evidence when they're done presenting their case in chief. There may be instances where there's some confusion or things need to be renumbered or a party is reconsidering whether to offer all of their exhibits into evidence, in which case more time may be warranted.
Yes, and updating the exhibit list and whatnot. So anyway, I'm sure we'll work it out, but I just wanted to remind of what we had done before.
Mr. Becerra, and then Mr. Berliner.
Yes, thank you. I want to make sure I can clarify the window for submitting evidentiary objections, because I have to admit I was a little confused by it at times in part one. So what you said earlier today was, please don't submit any evidentiary objections immediately, that you will look at the...
With respect to admissibility
Okay.
of testimony.
Okay, and see, I consider all evidentiary objections to be to the admissibility for the most part. So the way I understand the process going forward is we'll submit our evidence. You will then consider it. We'll get some kind of ruling, as we did in part one, that some things shouldn't be included or what have you. And then testimony will begin. And so it sounds like January 18th is the opening of the window for evidentiary objections. Is that accurate?
In terms of written objections, you mean?
Yes.
Okay.
And then so we would open that window, and then
We would.
people would testify, and at the end of their testimony, potentially, they would offer exhibits into evidence.
And if you will recall, during the rebuttal phase, at that time, I also asked for any remaining objections to be voiced.
Okay, so going forward, we would have from January 18th to the close of any given party's evidence to submit written evidentiary objections. Once somebody says, I hereby offer exhibits 1 through 2, being optimistic, is that the close of the window? I mean, once somebody says those magic words, are we unable to object any further?
Well, let me ask you to go back and read the transcript of the rebuttal phase, because my recollection is at that time, I ask if any parties have any objection. I allow for those objections to be voiced, and if necessary, depending on the circumstances, parties were given some time to submit more extensive written objections and responses, depending on the circumstances.
Oh, okay, and that's very helpful. So basically, we have, if you want to submit written objections, you should do so between January 18th and the close of any given party's testimony, and then you will ask at that time, are there any further objections, which might be based on cross-examination at that point, and then that's then the close, and maybe we'd have 24 hours or what have you to support those objections.
Depending on the objections.
Okay, that's very helpful. Thank you very much.
I don't believe it's changed that much from the rebuttal phase.
I think that's accurate. I just wanted to be very clear in my own mind as to how this would work, because there were times in rebuttal we were moving fast and I wasn't entirely clear exactly what the procedure was, and I don't think anybody got hurt by the procedure. I just want to make sure I understand.
I'm sure I would have heard due process complaints if that were the case.
I have little doubt about that.
Mr. Berliner.
Thank you. Good morning. Tom Berliner on behalf of the Department of Water Resources. I have a concern about the practice that we did adopt in Part 1 regarding changing when a party might be testifying and giving 3 days notice. It was a big improvement in Part 1 to get the 3 days as opposed to essentially real-time notice, but frankly, it was a pretty big burden when you had a party come up with multiple witnesses. We were preparing cross of another party, and it takes a long time to prepare cross. I mean, that's not something you do in an hour. It takes weeks for the big panels, for the technical stuff. If we have 3 days, really, we are already getting ready for that next week to 2 weeks worth of cross. And if you get 3 days and all of a sudden you've got 3 or 4 witnesses coming up, you really can't do an adequate job to prepare cross. And the burden falls on multiple parties who are trying to get ready for that. If it was an individual witness, fine, we can get ready for an individual witness in 3 days, everything else being equal. I'm sure there could be an extraordinary witness where you would say they're testifying as to so much that it would be next to impossible. What I'm wondering is if we could have a longer period of time when you have a party with multiple witnesses that's going to switch. And I think it's great that parties can switch. It's just, it would be extremely helpful to have more than 3 days notice. I would recommend a week.
Especially for the larger parties.
Yeah.
With more witnesses. Any concerns with that request or any joinder to that request? Mr. Becerra? And Ms. Tabor?
Yeah, I do object to that. I mean, we have moved very rapidly at times in this hearing. We've done our best to schedule witnesses as we've rolled along. We honestly don't have 3 days at times to figure out what the schedule is going to be. 3 days is in and of itself a little tight, given that you're trying to schedule multiple witnesses potentially across multiple days. Parties that are later in the cycle, all of these scheduling uncertainties tend to accumulate. And so, I mean, I certainly understand that the petitioners, have a lot of witnesses to cross-examine, but the scheduling becomes quite difficult, and hopefully this is not a problem, but 3 days is in and of itself a little tough when you're trying to schedule a panel of, 5 witnesses. So yeah, I think more than 3 days is inappropriate.
Ms. Tabor?
I just would like to join in Mr. Becerra's comments, and especially given this, that the hearing isn't continuous, there are gaps of days and it jumps over. It's just too difficult to predict with any certainty, and I think 3 days is tough but a reasonable compromise. So.
Any other joinder to Mr. Becerra and Ms. Tabor's concerns?
Tim O'Loughlin, San Joaquin Tributaries Authority. Yeah, I don't understand the request because my understanding currently as this is set out, all the testimony is coming out on November 30th and the hearing doesn't start until January 18th. And given that they're probably going to put their case on for 2 weeks, they have 2 months to prepare for cross-examination. So I think this is one of those little facetious things that are being thrown out.
No commentary, Mr. O'Loughlin. Ms. Desjardins.
But maybe
hold on, Mr. Berliner. Let me hear from all of those who would join in with their concerns before I give you the chance to respond.
Well, I think maybe
Mr. Berliner, hold on. Ms. Desjardins, I'm sorry?
I wanted to clarify my request.
Later.
I think we might be mixing.
Later, Ms. Desjardins.
Okay, that's fine.
I just wanted to say we did have some availability issues. As coming as a party towards the end of the schedule, there's a very limited number of other parties to switch with. And I jumped through extraordinary hoops and called everybody. And it's difficult to even find someone at the last, at who would testify after us if their issues arose. So I think that it's entirely reasonable. There's only a limited number of parties coming up towards the end, so I don't think this is as big an issue. And as Mr. O'Loughlin pointed out, for parties that are coming earlier in the protestants list, there is an extensive time to prepare before the hearing.
Ms. Meserve.
I would just suggest the 3 days, and obviously if we have more notice, we should provide it out of fairness. I think there were issues even with DWR's witnesses at the end where they switched around pretty quick, and I didn't have 3 days notice. So, I mean, we should do whatever we can to give people enough time, but more than 3 day requirement would be very hard to do.
Mr. Brodsky?
I think Mr. Berliner's concerns are valid. You're preparing for cross-examining a big panel and you've put weeks into it and then all of a sudden it's changed. So, but for us, I mean, we have witnesses flying in from out of state and people with teaching schedules and all sorts of things. So, I mean, to the extent the board is willing to allow for gaps in the hearings, we can be a lot more flexible in terms of when we present our witnesses, or if we knew well in advance. In other words, if I knew today my panel is going to be on January 20th, then I'll have them all here for sure on January 20th. But we don't know until a day or two, sometimes before we're going to go on, that's when we're going to go on. So if at that point, to be fair to Mr. Berliner, we might need to have a day or two gap in the hearings. That would be a way to accommodate everybody, to give him time and allow us to get our witnesses here.
All right. Do you wish to clarify now, Mr. Berliner?
Yes, please.
Before Ms. Morris? Okay.
Thank you. So I'm not concerned about a witness being available or not available on a Tuesday or a Wednesday or Thursday. We're flexible. We can take those witnesses whenever they're available. I'm not concerned about, gosh, we thought so-and-so was going to testify on Tuesday and now they're going to testify on Friday. That's fine. What I'm concerned about is you have a typical witness or party in this proceeding with 5, 6 witnesses who are scheduled to testify. And let's say it's group, not just picking a number, I don't know what groups these are. Number 20 decides to switch with number 10. And you were getting ready for 10, 11, 12, et cetera. And now 20 all of a sudden is going to go and you've got 3 days notice and you've been working on 4 or 5 other parties that you have to cross. Now you have to drop everything and refocus what you're doing and going for that other party. And there are a lot of witnesses on those panels. So Mr. O'Loughlin's correct. We will have 2 months to get ready, but we have 2 months to get ready for a lot of parties. And we all know, I mean, the lawyers that do this, we all know you can't get ready for everybody ahead of time. You're getting your own witnesses ready. You're making sure their testimony is sound. You're starting to do cross and figure it out. But when you do cross, you spend a lot of time on the technical stuff. It just takes time. So I'm concerned about major changes where you've got a party, not within a party, or not a day or 2 or 3 here or there. All that stuff's fine. I'm concerned when you are preparing for party 10 and all of a sudden party 10 moves way back and other parties come up and you got 3 days notice and you get notice on a Friday and you're going on Tuesday.
Okay. Ms. Morris, did that address your concern? All right. I would suggest, and I'm coordinating with my co-hearing officer on the fly here, that we go ahead and remain with the 3 days, but obviously we will take unique circumstances into consideration should that happen. Yep. Okay. All right. Moving on then. We had advised in our agenda that was sent out on Monday that we wanted to get an update on where settlement discussions are. So, as you know, we encourage parties to attempt to resolve outstanding issues through settlement. So, petitioners, please update us on whether there are any ongoing settlement discussions with any of the parties and what that current status is.
Well, the department remains open to considering settlements with anybody and everybody who wishes to speak with us. At the moment, there is no update to be given about status of the settlements that were initiated. Primarily, those settlements have not progressed significantly since the last time we spoke, and The focus has been principally on CEQA settlements at this time. Those CEQA settlements are proceeding, but they're from a different process, so they're not necessarily precisely on point for this hearing. To the extent that they have overlapping issues, some issues may be resolved through the CEQA process.
Anything to add, Ms. Offenberg?
No, nothing to add.
All right. All right, so earlier I asked you to review the staff summary of the party participating in Part 2. Does the information accurately reflect the submitted supplemental notice of intent to appear? Does anyone have any concerns with the summary? Any clarification, any corrections? Please come up.
Good morning, Dustin Cooper. I spoke with Mr. Baker. There's a minor typo as to the draft party witness list. 3 of my clients are participating just under cross-ex and as rebuttal that are not listed. Those are Nevada Irrigation District, Paradise Irrigation District, and South Feather Water and Power Agency.
Thank you. Anyone else? For anyone who may not be here today, let's give you until noon tomorrow to notify the staff and the service list of any corrections that need to be made to this. All right. Then it seems like we will be wrapping up before lunch. A transcript of this pre-hearing conference will be made available on our Waterfix Hearing website as soon as possible. We will take under consideration the requests for clarifications that were stated today, and we will issue some additional direction shortly. Keep in mind that all of the notices and ruling letters issued to date are still in effect unless modified by us and are available on our petition hearing website. We remind you again of the guidance document that was provided as an enclosure to today's agenda. It summarizes the hearing procedures and issues addressed in prior rulings. And also a reminder that the prohibition on ex parte communication is also still in effect, which generally means that all substantive hearing communications need to include all members of the service list. The most current version of the service list is also available on our website. With that, thank you all for participating today. We will see you when Part 2 of the hearing resumes on January 18th, 2018.